Good afternoon. My name is Darren Bax. I'm a senior research fellow here at the Heritage Foundation. Please make sure you turn off your phones or put it on silent mode. I want to thank all of you for coming here today and also everybody who is watching it online. I also want to give a special thanks to the Pacific Legal Foundation for co-hosting today's event. On January 23rd, 2020, the EPA and the Corps finalized a rule called the Navigable Waters Protection Rule. The rule is the agency's latest attempt to define the term waters of the United States under the Clean Water Act, and that term is often referred to as simply WOTUS. Navigable Waters Protection Rule is a replacement for the repealed 2015 Obama administration rule called the Clean Water Rule. This WOTUS definition is really critical because it clarifies what waters can be regulated by the EPA and the Corps. So here's how the program will be structured today. We're going to divide it into three parts. First, we're going to hear from two experts. One expert is going to provide some background for us on this new final rule, and then we're going to learn what's actually in the final rule. Tony Francois will provide the background. Tony is a senior attorney at the Pacific Legal Foundation and has litigated cases across the country. He's definitely a true champion of liberty, defending property rights and challenging government overreach. Deidre Duncan will provide us the details of the final rule. Deidre is a partner in the law firm of Hunnan Andrews Kurth and is a co-leader of their environmental practice. She's one of the top Clean Water Act attorneys in the country and represents a wide range of clients on a wide range of environmental issues, including Clean Water Act, ESA, and NEPA. Both Tony and Deidre have worked extensively on the WOTUS issue specifically, and I sincerely appreciate them joining us today. Secondly, after they provide their presentations, I'm going to join them. We're going to have a discussion, and the goal of having that discussion is to dispel some myths that are out there, add some context to the issues, and provide additional insight and perspective. And then finally, we'll open up the floor to your questions. So let's get started with Tony. And Tony, can you provide us some background on the WOTUS issue?
To the Heritage Foundation for hosting this event, along with PLF, and also thank Deirdre for joining us today. It's an honor to be to share the podium with you. As Darren mentioned, one of the very important issues in the administration of the Clean Water Act is its use of the term navigable waters to describe what activities are actually regulated by the Act. Discharges to navigable waters are what the Act regulates. There is a very able and interesting history of how the agencies have defined that term over the decades since the Act was first adopted in 1972. In the preamble to the rule that EPA and the Army Corps just announced, I would commend that to you if you're interested in the details of the history. It does run in the hundreds of pages, though. So if you're not that interested in the history, you probably won't read that, and I won't bore you with it. Suffice to say, though, there's been a lot of controversy over those decades because the agencies have, almost from the very beginning, defined that term very broadly. The second aspect of controversy surrounding it is that both from agency practice and ultimately Supreme Court limitation, despite that very broad view of what navigable waters means under the Act, there are a lot of things that over the last 40 years, the Act has not regulated. Irrigation ponds and, a wide variety of ditches defined different ways at different times. And ultimately, as a result of Supreme Court decisions in Solid Waste Agency of Northern Cook County in 2001, and then Rapanos in 2006, the agencies have been under Supreme Court limits in what they could claim authority over. The next major point I want to make in the lead up to the Trump administration's new rule is that most recent Supreme Court decision, Rapanos, bears a substantial responsibility for further muddying the waters, if you will. The Supreme Court decided for the particular landowner in that case that the agency regulations excessively defined what was navigable waters on that particular property. But the case does not provide a clear rule supported by a majority of the justices of the Supreme Court to define what the term means. Four justices adopted a fairly narrow reading of the term in an opinion authored by Justice Scalia. And Justice Kennedy separately concurred in the result, but offered a much more expansive view of what the agencies could regulate. Since 2006, the agencies have struggled to implement the decision. The regulated public has struggled with it. And the lower courts, I think the short way of saying it is that the lower courts have largely adopted Justice Kennedy's expansive reading of the act. And yet there's controversy over whether his opinion is actually the controlling opinion in the decision. So one thing I'll say that kind of sits above and outside the discussion of the new rule is that I think until the Supreme Court revisits this question and arrives at a majority opinion that provides a reasonable and clear interpretation of the term navigable waters, everybody is going to continue struggling with this. There's a great short concurrence that Chief Justice Roberts wrote in the Rapanos decision, which is that as the result of today's decision, the Rapanos decision, regulated parties will have to feel their way on a case-by-case basis. So next I want to highlight a couple of the cases in which people were feeling their way on the case-by-case basis in the wake of the Rapanos decision to try to sort out whether or not the Clean Water Act applied to their property. I won't go into the details of their cases, but just to give you an idea of the types of ambiguities that the Act suffered from post-Rapanos. So that photo is an aerial photograph that shows, and I'll highlight it here, except it doesn't show up on the TV, dang. All righty. So there's a couple that owns one of the vacant properties in that photo. There's a kind of a major road that runs, side to side through the photo, and then a vacant area, and then a series of houses that are right next to the lake. The lot in question is shown in this photo. It's bounded on both ends by roads that have been there for decades. It has, based on the EPA's own investigation of the site, no surface water connection to any other water body. And yet in 2007, EPA claimed jurisdiction over it because it's the tail end of a historic peat bog, which is mainly situated north of that road. So that's a case that's been going on. It's still actually going on almost 13 years later. Okay, so this is one example. Next example, raise your hand if you see the wetland in the photograph. Okay, so that greener area in the middle of the photo is actually a vernal pool and routinely classified as jurisdictional by EPA and the Army Corps. This happens to be in California. But that's an example of a wetland that does not directly abut, but occasionally does drain through a network of swales to a seasonal creek. This particular wetland, this property, there's a number of these types of wetlands on it, was the subject of a more than $1 million settlement of an EPA Army Corps enforcement action against the landowner for plowing it. This picture is of a rivulet that is about 40 miles from the nearest actually navigable river. It is, by the government's description, about a foot wide and about a foot deep. And they characterize the flow shown in the picture as about 3 garden hoses worth. This is the map. I won't try to show you the connections, but this is the map that shows both that site and the related navigable river downstream, again, 40 miles distant. These were both exhibits in the government's prosecution of a gentleman for digging a fire protection pond in the course of that rivulet. He spent 18 months in federal custody for not realizing that that was federally regulated navigable waters under the then in effect rules. And then this final photo shows, this is similar, this is an aerial photograph. It's nearby the property where I showed you the ground photo of the vernal pool. The blue on that photograph was mapped and delineated by a wetland consultant in 1994 in support of a potential golf course and retirement housing development. And I mean, that map is probably why that project never went forward. But that's farmland. And so, the stuff that's mapped in blue there, when you look at it on the ground, mostly looks like that. And so it's very difficult for landowners to know, which of these are going to be considered by the government, as blue on a map like that, and therefore subject to regulation. So these kinds of controversies and difficulties led the Obama administration to adopt a rule in 2015 that attempted to clarify what was covered and what wasn't. That rule took a very expansive view of Justice Kennedy's expansive view of the meaning of the term. It ignited an enormous amount of controversy and significant litigation. 4 separate district courts and 1 circuit court ruled in various ways against the 2015 regulations defining the term. And 2 of those courts actually remanded the rule to EPA and the Army Corps for further work. This leads then to the Trump administration's announcement at the end of February in 2017, so almost within a month of taking office, almost exactly 3 years ago today. And that announcement was an executive order directing the agencies to reconsider the 2015 regulation and to consider, in looking at that question, whether or not to replace it with a rule that was based more on the Scalia plurality from Rapanos, which has a much narrower view of the act, and laid out some policy bases for making this direction. One was economic concern, the impact that expansive regulation under the Clean Water Act has on development and economic activity. Another was, comity or federalism with the states. The Clean Water Act does have as one of its co-purposes proper sharing of authority with the states over waters that the states should regulate. The process that the EPA used it was a very complex, had a lot of moving parts, but it culminated a little over a week ago with the announcement of a new rule. It's not been published in the Federal Register yet, but it is available on the EPA's website. And so now we're looking, instead of what's gone on in the past, at what the administration has done with the new rule. And with that, I'll turn it over to Deirdre.
Thank you very much. Let me see if this gets to my slides. Uh-oh.
They'll load it.
What?
Get to it.
They'll put it up.
Put it up.
I can just talk. Oh,
Are you talking while they?
wait, it's up there.
There you go.
Yeah.
Okay, let me go back here. Okay. I think we've covered all of this. It was published, pre-publication version, about a week ago, 340 pages of fun. I've been waiting for it to be published in the Federal Register because I prefer to read a shorter set of pages, but it hasn't. But when it finally is published in the Federal Register, it'll become effective 60 days from that date. Importantly, just as a practitioner, I'm always interested in kind of what happens with JDs that were done under prior rules or guidance, and do you have to go get another JD? They said that you can rely on the JDs that you have unless you request a new one. So essentially there's some certainty that if you have a JD and you like your JD, you can keep it, or you can ask to avail yourself of the new rule. So just hitting the high points, these are very familiar categories. Not a lot really looks different. They've consolidated the categories into 4 major categories of jurisdictional waters. Here they are: the territorial seas and traditional navigable waters, the tributaries, a new kind of combined category called lakes, ponds, and impoundments of jurisdictional waters, and adjacent wetlands. So this looks relatively simple, but each of these categories has definitions and further definitions within those definitions that really get to the meat of what's going to be regulated. The first category, and I'm just hitting the high points here, we're hopefully going to delve in deeper in discussion, but just to kind of make sure everybody has the lay of the land, I'm going to hit the high points. Territorial seas, a relatively non-controversial category. People generally know what those are. But then what the rule does is retain the previous regulations category of A1 waters as is. Those waters are waters which are currently used or were used in the past or may be susceptible to use in interstate or foreign commerce. This category also includes those waters that are subject to the ebb and flow of the tide, the tidal waters. And as I said, this is essentially, it is the same definition of the A1 waters as has been in the regulations for a long time. The agencies have chosen to eliminate a category called the interstate waters, which generally people supported eliminating that and including it kind of within this category. We'll talk more about this. In my opinion, this is one of the more disappointing aspects to the rule, but we'll talk more later. The next category are tributaries, and tributaries has been in the rule for a long time. The 2015 rule had a category called tributaries. This rule has a category called tributaries, but what this rule does is regulate perennial and intermittent rivers and streams that contribute surface flow to traditional navigable waters in a typical year. Perennial is defined as surface water flowing continuously year-round, and intermittent waters are defined as surface water flowing continuously during certain times of the year and more than in direct response to precipitation. Ephemeral waters are not included in this definition, and I'll explain how they're defined later in the next slide. The concept of typical year is a very important concept under this rule. It tells you whether a water body is going to be perennial or intermittent. It's also used in the lakes and ponds category. So it too has a definition, and there's actually a fact sheet and other materials that the agency have put out about how you determine a typical year. And it's fairly scientific. In nature, you're looking at a lot of scientific documents to determine essentially that an area is wet, is acting in having surface water flowing during, and it's a normal time of year, and that happens it's a normal time of year. You're not looking at the feature when it's a drought. You're not looking at it when it's in a flood, but it's essentially acting as it acts normally. That's the basic gist of what a typical year is trying to get at. As I said, the tributary definition excludes the concept of ephemeral features, and it defines them as surface water flowing or pooling only in direct response to precipitation rain or snowfall. So whereas intermittent features were flowing more than in direct response to precipitation, ephemeral features are only flowing in direct response. So this whole issue of the distinction between what is an ephemeral feature that is only flowing in direct response versus an intermittent that flows more than in direct response, this is a very gray area and is going to actually play out, I think, more in implementation. The tributary definition also includes the notion of certain kinds of ditches. Ditches that meet this tributary definition and are relocated or constructed in a tributary or adjacent wetland will be in. And these are two, you have to have both those requirements. So a ditch that's perennially flowing, it flows all the time, it has water in it all the time and contributes flow to a downstream water. Just that fact alone doesn't make the ditch jurisdictional. The ditch has to also have relocated or be constructed in a tributary or adjacent wetland. Moving on, as I said, they've created this new category. There was a category, I mean, lakes have been regulated, ponds have been regulated, impoundments was a category, but now there is a new kind of combined category called lakes and ponds and impoundments of jurisdictional waters. These water bodies have to contribute surface flow to a TNW, again, in a typical year. They have to connect either through channelized conveyances, pipes, et cetera, to an adjacent TNW, or, and I don't have this on here, be inundated by another jurisdictional water body. So there's this notion of one of these lakes or ponds or impoundments actually being flooded or inundated by an otherwise regulated water body. Final category are adjacent wetlands. The agencies do a lot to try and give more guidance on what makes an adjacent wetland. A wetland that abuts a jurisdictional water actually physically touches a water, jurisdictional water is regulated. A wetland that is inundated or flooded by a jurisdictional water is an adjacent wetland. And then it deals with the berms and artificial kind of barriers. So a wetland that is separated from a jurisdictional water body by a natural berm or bank or sand dune will be in, regardless of whether there's a connection. But if you're separated, if you're an adjacent wetland and you're separated from a jurisdictional water body and you're an artificial feature like a dike or a flood control levee, you have to have that direct hydrological surface connection in a typical year. So there's a difference in treatment between natural dunes or natural features and artificial features when it comes to something being an adjacent wetland. The rule is good in the sense that it clarifies that in order to be a wetland, you have to satisfy all three wetland factors. You have to have the hydrology, vegetation, and hydric soils. And then finally, there are continued to be helpful exclusions from the definition of WOTUS. And I just highlighted two, the prior converted cropland and waste treatment exclusion, which were exclusions in previous regulations, but were that had their own confusing histories associated with them. And the agencies have done a fairly good job. I think this is one of the bright spots of the rule is in really giving good clarity on these exemptions. It's not to say there aren't still questions or they aren't perfect, but I think they've done a good job making these two exemptions in particular a lot more useful and obviously for the agricultural community and really industrial manufacturing, any really entity that does business and has to manage their waste, the waste treatment system is going to be much, much more useful. And that's the overview.
Thank you, Tony and Deidre. So in the executive order in 2017 that Trump issued, it talked about the EPA and Corps coming up with a final rule and at least considering making it consistent with Rapanos, the Scalia opinion and Rapanos. So my question is this final rule consistent with the Scalia plurality opinion and Rapanos? And if it's not, how is it not consistent? I'll just open up to either one of you or both.
You want to start?
It's actually a hard question to answer. The approach that the agencies took is to try to distill what they describe as common principles from both the plurality and the concurrence, and to use those common principles to build the rule. It's not an unreasonable thing to do. I think there's probably going to be a legal debate whether you can actually do that with a fractured Supreme Court opinion. The way the Supreme Court has said you deal with fractured opinions that they issue, the analysis is complex, but the outputs are one opinion or the other. And, the commonalities can help you decide one or the other. But I think that there's going to be a legal dispute whether or not the methodology of simply trying to blend the two rules, is available to them. They concede in the preamble that if you simply look at each of the two opinions, the rule isn't strictly, within the boundaries of either. But again, their approach to it is to try to find what's common between them and to base the rule on that.
I agree with what you said. I do think, though, this rule is largely a plurality-driven rule, at least on tributaries. I think the agencies are focusing on continuous flowing waters. They're looking at trying to exclude waters that don't flow frequently and predictably. And there's a gray area there, and I know people would like a very clear line that says these waters are out, but it's hard. I think there are going to be a lot of ephemeral waters that people can clearly say are out. There are going to be some intermittent waters that look like ephemeral waters, and you're going to get into that whole discussion of does it flow continuously at certain times of the year in a typical year, and is that more than in direct response to rainfall? That's what people are going to have to deal with on the ground. I think what the agencies were essentially trying to do is adopt what was in the Rapanos guidance on relatively permanent waters, which was waters that flow seasonally, kind of predictably during a certain season, are in. And they've really eliminated from their jurisdictional test this case-specific significant nexus approach, which is what the 2015 rule did. It's what the Rapanos guidance had in it. And that was extremely problematic. That was, kind of applying the strict tests of both Scalia and Kennedy. And as Tony explained, they've kind of merged these into their own kind of new manner of establishing jurisdiction. But to me, it's more closely aligned with the relatively permanent waters concept that Scalia was trying to get at, certainly than a significant nexus approach, where you're aggregating, waters all over the landscape to say that something small has significance.
Yeah, I would add, too, that the degree to which the new rule changes the agency's view of adjacent wetlands is dramatic and almost entirely the plurality view of it. If you think back to the that blue overlay photo I showed you, so most of the wetlands on that particular property are at some distance from anything that flows like a tributary, even under the new rule, under any definition of the term. And yet the agencies were quite readily able to establish that. Excellent. So all those little blue dots that are, kind of away from the streams that you see depicted in there, the agencies would have no trouble establishing those as adjacent under the old rules. The definition of adjacent was bordering, contiguous, or neighboring. And, so from one perspective, neighboring is where a lot of the mischief came in. And, what's neighboring? Well, it's pretty far away. It can be neighboring. Under the new rule, again, you would have to have an engineer look at that on the ground and in that photo. But I would say most of the wetlands in that photo that have, aren't connected by a blue line to anything else are probably excluded by the new rule. And that's going to, I think, have a dramatic effect on the regulated public. And is a very significant change in the agency's view of the scope of their authority. And again, I mean, there's some question about whether the plurality would agree that something that actually is physically separated by a natural barrier would be included. But nonetheless, so there's a couple other things that the preamble makes clear, which is that you can't daisy chain adjacent wetlands. So in that photo, you might find one that's like right next to a tributary, and then another one right next to that one, and on to get out to the middle of those fields. And the preamble makes clear that at least the way this administration views that, you only get like the first adjacent wetland, and beyond that is non-jurisdictional. So I think that's also pretty strongly reflects the plurality view.
So arguably the most important water to define is the traditional navigable water, or A1 water that was mentioned, because really everything kind of starts from that. Once you define the traditional navigable water, everything, the tributaries, adjacent wetlands, and are connected back to that definition of traditional navigable waters. The problem is if you have too broad of a definition, which I think the proposed rule had, and now the final rule has, you might wind up with a situation that some people might stretch the Commerce Clause to somehow decide that something actually does impact interstate commerce. So I guess to ask both of you, do you have concerns about the definition? And Deirdre, you mentioned that you did. And what are those concerns?
Yeah, I was disappointed that, but not surprised, because the proposal didn't propose direct changes to that part of the rule in the rule language. And so I think you can tell that the agencies in their final rule were trying to stay very close to what they had proposed so as not to make the rule potentially vulnerable from a logical outgrowth perspective, which the last rule suffered from. So, I'm not surprised that they left it alone. The problem is the A1 uses this language, use in interstate or foreign commerce, and use, and it's not just use in, it's past use, potential future use, and that can be, and I've had clients who that language has been used to essentially, say you're using the water for an industrial economic purpose, it's an A1 water, and it could, if pushed to a very, kind of extreme position, could eat up the entire rule. I know not what this administration intended, and when you read the preamble, they're trying to put limits on it, but they didn't change it. They didn't make it clear that it had to be transporting commercial navigation, commerce, which is what the term navigable really implies. They didn't add that in there. They didn't address or didn't make the point that the A1 waters are coterminous with the Rivers and Harbors Act waters, which was another suggestion that was made. They left it as is, and also disappointingly did not withdraw the Appendix D to the Corps instruction manual that went along with the Rapanos guidance. So they left in place this Appendix D, which is this 2 or 3 page document that essentially gives a very, very broad meaning to the A1 traditional navigable waters that uses concepts like recreational use. And again, the preamble tries to cut back on, they question that there were, or they state that there were problems with Appendix D, but they don't withdraw it. So, we don't like Appendix D. It shouldn't mean what it's saying, but we're leaving it in place. So that, again, is problematic. I think just in maybe fairness to the administration, they can get rid of Appendix D at any time. They can issue a new guidance document, and maybe they will. But at the end of the day, the rule language is still the rule language. It says use in interstate or foreign commerce. And right now, Appendix D is in place. So until they actually issue guidance that maybe gives a little bit more limits on what the rule language says, we're stuck with a very broad notion of the traditional navigable waters. And even if this administration issues guidance that is better than Appendix D, what's to say that a new administration won't just go back and change that guidance, get rid of it, and potentially make it even broader? So those are all my concerns with traditional navigable waters as, under this rule.
I don't have a whole lot to add to that. There's a couple of curious examples that the Army Corps has used, in the past. I'm aware of one case. It might be with one of your colleagues, of one of the agencies claiming authority over a fairly modest-sized pond at a rest stop, a mile from a interstate freeway exit that had no connection to anything else in the world. Might have been like a little fishing pond or something like that. But the rationale for claiming authority over it was that interstates are all about interstate travel and commerce, and so people getting off the interstate freeway would stop here and eat their lunch and kind of enjoy the scenery, and therefore, as an A1 water, that was waters used in interstate commerce, and therefore subject to Corps regulation. In the Swank decision in 2001, the Supreme Court struck down what's called the migratory bird rule, which meant that, and this again is an exercise of the agency's authority under this category, that if birds fly across state lines and use a particular water body for habitat, that alone establishes agency authority over it. Swank struck that down as an unreasonable reading of the act. The same in the same bullet list that the migratory bird rule appears, there's another factor, which is any water used to irrigate crops that are sold in interstate commerce is subject to regulation. So, the agencies have this history of, being fairly aggressive with that part of their authority. The preamble, I think, tries to tamp that down, but I agree that as guidance, that's subject to administrations, taking it or giving it. And that there's a pretty clear history of the agency staff, taking an expansive approach to use of this authority.
Let's go through a few more questions real quickly. So we discussed the problem of intermittent waters. There was kind of a desire to provide more clarity as to what intermittent means. It may not be too clear what the difference is between intermittent waters and ephemeral waters. Just some thoughts on that whole intermittent issue, Tony?
Well, so the preamble goes into a lot of detail, both on what the agencies mean by the difference between ephemeral and intermittent, and gives examples of streams that may look like they're flowing intermittently, but they're actually flowing in response to multiple rain events that are close in time to each other. I do think there's going to be kind of a boundary problem, on the, I want to say on the margins, but I'm not sure, how marginal that is. I mean, again, that the, blue delineation map I showed you, a lot of what's mapped in there is drainages or tributaries. It's not clear that they do flow more than in direct response to precipitation. So it's when you dig into the way that those determinations can be made in the preamble, I mean, there's two things that stand out. One is there's a wide variety of methodologies that agency staff can use to make that decision. And, I think it's fair to expect that the staff will use a methodology that favors their ability to regulate. Secondly, even with all that, it admits that there's going to be some uncertainty about the boundaries of this. So in a way, maybe the proof of this is going to be in the field. Are there significant tributary systems that would qualify under the old way of looking at it that wouldn't under this? And I don't know what the answer to that is, frankly. Part of it is that the way that it decides whether something's a tributary is at a technical level so different than the old methodology that we'll need to see how they do it to know some of that.
Arguably, one of the biggest the agency's kind of disregard of Rapanos, Scalia's opinion, or Rapanos, is the fact that he would not have covered intermittent waters, except he would have covered arguably some seasonal waters. And that's addressed in footnote 5 of the Rapanos opinion. So, I mean, what Scalia was trying to do is kind of have a very clear, bright line rule to basically exclude, for the most part, most waters that were, at least at a minimum, they had to be at least seasonal waters, at least 90 days of continuous flow. And I would have argued for a longer period of time, because Scalia also argues that there needs to be ordinary presence of water. This definition doesn't include the ordinary presence of water, in my opinion, and nor does it at least require 90 days of continuous flow. Thoughts on how that might have been? Were they just simply concerned about the logical outgrowth issues?
Well, I kind of disagree. I think Scalia talked about relatively permanent waters. He talked about seasonal waters. But exactly what he meant, he wasn't using the terminology that the agencies have set forth here: perennial, intermittent, ephemeral. They've established their own definitions of those terms. And one point I just wanted to make was they're not and they make this point as well, they're not the common scientific definitions of those terms. They're their own definitions. And so whereas intermittent waters, under kind of the scientific definition, like consultants used, is that there's some relationship to groundwater, that the groundwater essentially creates a base flow to the stream for portions of the year. Whereas ephemeral waters really just have their flow in response to rainfall events, and there is no groundwater source of flow. That's not what they chose to do in this rule, and that's in some ways part of the problem, because it's like new definitions, and so I don't really see them necessarily being inconsistent with Scalia. I think, again, they're trying to faithfully understand what was he concerned with, and it was the notion that there be water in a water body, it be a water body, and it flow with water predictably, seasonally, and that I do think is what these definitions are trying to get at. So in that way, I guess I disagree. I think it is consistent with Scalia, just set forth in a different way.
Okay, before we get to their questions, there's a couple of criticisms of the final rule, a lot of criticisms actually, but let me just throw a couple out there. One, that this final rule is going to mean that a bunch of waters are no longer going to be protected. And the other argument is that this final rule ignores the science. Just want to see what you guys thought.
Well, on the first point, there's a lot of water features out there that, particularly in the area of adjacent wetlands, that this rule says the agencies will no longer regulate. And I think that has to be acknowledged, for what it is, and that from whatever perspective you're looking at it, whether it's from, how does this help the regulated public, or, how big a change is it or how significant a move is this? It's significant. That doesn't mean that they're not regulated, though. For a lot of these water features, it just means they're not regulated twice, once by the state and once by the federal government. In most of the cases I've been involved with, there's a parallel state regulation program for streams and wetlands. California, when SWANK was decided, and in the early 2000s, people trying to figure out, what are we going to do, with what SWANK doesn't cover. Builders in California were telling me, oh, we'd prefer to have the Corps. We don't want the state of California regulating us. So, there may be some states that have less robust protections for some of these water features than the federal government did. It's the EPA and the Army Corps' position in this rule that that's for those states to decide. And, there's democratic processes in those states. And, I think it's also important to assess what's the significance. So again, if you think back to that, blue overlay on the map, that's 3 miles from the city of Red Bluff. It's 8 miles from the Sacramento River. Nobody hunts there, nobody fishes there. It's a farm and ranch field. How significant an issue is it really? If only the state of California tells people what to do there. It's factually correct that this changes the status of a lot of regulated waters, but I think it's overblown to say that all of a sudden, you'll be free to, construct a sewage plant, anywhere you want.
Yeah, I think a lot's going to depend upon the implementation of some of these points that we talked about, this kind of gray area between intermittent and ephemeral. But I agree. If you start from the premise that the 2015 rule could have regulated any water anywhere, then yes, this probably doesn't regulate as many waters as that. And I think it's the right place to be to say that not all water everywhere has to be regulated by the federal government. And so what this rule has tried to do is establish a framework for essentially looking at what waters are truly important, what waters are less important and less important from the federal perspective and could and should be regulated by the states as a matter of land use. That's the framework this is trying to establish. And again, I don't think that means those non-federally regulated areas aren't necessarily protected. I think the same concept really applies to the science question. The connectivity report, which and the SAB review of that report, which I participated in for many years, simply said all waters are connected. It didn't say, that all waters have a significant nexus. It didn't say that all waters have to be federally regulated. It didn't establish a line. They recognized that science can't create a legal line, and they recognize that waters are connected on a continuum, with perennial and intermittent waters being, more connected and more important to downstream navigable waters, and then ephemeral streams and ephemeral waters on the other end being less. And, it really said that it's ultimately a legal question. And so I think this rule is very much informed by that science. I think they did a really good job in the preamble articulating that. I think this concept of typical year, which requires the review of precipitation data and climate data, really infuses a good amount of science into those gray areas. So I completely disagree that this rule disregards the science.
Thank you. Let's take some questions from the audience. Yeah, and before, thanks for say your name and your affiliation. And
R.J. Smith, Competitive Enterprise Institute. Question for Deirdre. On your comments on tributaries, you said it excludes ephemeral features such as surface water pooling from rainfall. Now, is that going to exclude the millions of vernal pools all across the Central Valley of California? I mean, if it doesn't rain, those things are going to be empty. They're not going to have any water in them. Do we know yet?
Well, I mean, under the prior rule, those waters would have been regulated under these case-specific significant nexus determinations where they would aggregate all of those waters up. That approach is gone, and so, you know, I'm not a Corps regulator, but I would say there's a good case that those, you know, those areas, if they are in fact isolated and not near any other jurisdictional, not separated by a sand dune or a natural berm from something that's a TNW or another jurisdictional water, they should be out. But again, that's the kind of proof that's going to be in the, you know, implementation. So.
But of course, they still have endangered prairie shrimp in them, so they'll be regulated under ESA, but at least that'll help.
Well, but, right, because so one of the issues that's been raised about this is that in those vernal pool complexes, a Clean Water Act permit may be the only federal permit one needs that would raise consultation under the ESA. And I mean, there may be cases for ESA reasons where somebody would rather have the incidental take protection that comes with the Clean Water Act permit. But that raises a different issue, which is that those species are listed as threatened rather than endangered, and the service is illegally extending the take prohibition to them. But that's for another panel.
Adam over here.
Oh, no.
Oh, okay, yeah.
Diane Katz, Heritage. We've talked primarily about the bodies of water that would fall under regulation here, but not the actions. And is there any change to land use definitions that can, or, you know, what can and cannot be done on the waters? And then just very quickly also, what strikes me about this in particular is that the courts and the executive branch have been going over back and forth about this for decades, and Congress is basically absent. And is there any chance, hope really, that we'll get something definitive from the body that's supposed to do all this?
The last one is no. Unless anyone disagrees, they can, oh, you okay, good. But I'm glad you asked the question. I think you're asking about some of the activity exemptions, and I actually just noticed this in reading. I mean, it's 340 pages. There's a lot in there. Really, the preamble has so much more that I'm still absorbing and will be absorbing for a long time. We all will. But there is a very interesting discussion on actions with respect to the 404F exemptions for ditch maintenance, for those who care about ditches. I think there's some very helpful language that tries to give better meaning, more helpful meaning to ditch maintenance, allowing, you know, under the 404F exemptions, it talks about essentially exempting construction and maintenance of certain ditches. And I think that they're trying in that discussion to essentially encourage the routine maintenance of ditches, which has in the past been problematic, triggered permitting requirements, and I think they're saying you should rely on the exemption and not necessarily have to obtain a permit. How that plays out, you know, in practice, that I don't know. But that was actually a very interesting and helpful discussion, because I had been thinking to myself, there are a lot of ditches that, under the definition, they flow water perennially, they hold water, and they recognize a lot of, like, stormwater management systems were constructed in wetlands or can relocate streams, and those still are tributaries under this rule, but they recognize this concept of ditch maintenance, which is pretty important. So I think that was another pro. to this rule.
I think Congress would take action on this if the Supreme Court revisits Rapanos and a 5-vote majority settles on something like the Rapanos plurality, which would mean that this rule is about the outer limits of what the agencies could do. And I think that would change the status quo enough that you might see congressional action. But short of that, they've got no need to or reason to.
Joe Gilson with Senator Grassley. And going back to your previous answer, do we have a timeline of both implementation and then when the Supreme Court is likely to take it up?
Well, so the second question first, there will certainly be litigation over this rule. The litigation over the 2015 rule went through a lot of, went down a long and winding road. It got revived, about 2 years ago, and at this point is still mainly in the district court stage. So I would say Supreme Court review of anything under this rule is probably 2 to 3 years out, unless something more rapid happens. There are also cases that are pending that may raise this issue, but aren't ready for cert petitions yet. The Robertson case would have, if Mr. Robertson had not unfortunately passed away before the Supreme Court heard his cert petition. The Sackett case is pending in the Ninth Circuit and raises this issue. There's a case out of, I think, the Western District of West Virginia that's not quite final in the trial court that raises the issue. So there's a variety of ways they could. Implementation, I know we were talking about this earlier. I mean, it's hard to say how long the agencies will need to, and they're going to need to very thoroughly revise their agency staff manuals, because it's not just the footprint that changes, it's the methodology for determining what belongs in the footprint is quite different in this.
One more question? Well, thank you very much. Join me in thanking the panel.